get started with our second panel. As Judge Martin said, I'm Steve Vladeck from the University of Texas School of Law. I'm going to briefly introduce our five incredibly distinguished panelists. If I gave them their due, that would take all of our time, which actually might be a pretty useful filibuster. But just to get right to it, starting all at the end, Alexia Korberg is a partner in the litigation department and deputy chair of the M&A litigation practice group at Paul Weiss here in New York. And as especially relevant here, they have an extensive pro bono practice with a focus on vindicating the rights of LGBTQ plus people and reproductive rights. So welcome, Alexia. To Alexia's left is Alex Reinert, who's the Max Freund Professor of Litigation and Advocacy and Director of the Center for Rights and Justice at the Benjamin and Cardozo School of Law at Yeshiva. Very, very far from here, 9 blocks, 10 blocks. Among lots of other things, Professor Reinert has litigated numerous significant civil rights cases, including arguing on behalf of post-September 11th detainees before the Supreme Court in Iqbal. Alex and I have an equally good one-loss rate in the Supreme Court. The next one will be the first for both of us. Next to Alex is Noah Rosenblum. Noah is an assistant professor here at NYU, where he's previously the Samuel Goley Fellow in Legal History. Noah works on state and federal administrative law, constitutional law, and legal history, and is a frequent commentator on the New York State judiciary. And I can say that Noah and I are the kind of people who were friends on Twitter long before we actually ever met in person. Seems to be par for the course. To Noah's left is the Honorable W. Lewis Sands. He's a senior U.S. district judge for the Middle District of Georgia with his chambers in Albany. After a distinguished career as a state and federal prosecutor and in private practice, Judge Sands was appointed to the federal bench in 1994 by President Clinton and served as chief judge of the Middle District from 2001 to 2006. And last but certainly not least, Kate Shaw is a professor of law and the co-director of the Florsheim Center for Constitutional Democracy at Cardozo, and also co-host of the very popular and very cool and award-winning Strict Scrutiny podcast, the only mistakes of which have been letting me come on every once in a while. In addition to her accomplished academic career, Kate worked in the White House counsel's office as a special assistant to the president and associate counsel to the president, so you guys know of what you speak. All right, Alex, I'm going to throw you under the bus to get us started. Okay. So the first panel really was, I think, a very thorough exegesis and inspection of, can we just say nationwide injunctions? Am I going to get in trouble for using that shorthand? But I guess, Alex, I suspect you have some of maybe my same instincts, which is that that's not all that's going on in this space. We heard something about the state attorneys general in the first panel. You've been working on these cases, from the inside for a while. Like, what do you think has changed so much in the last 10 or 15 years, and how much of that could we actually attribute to this one procedural device?
Well, so thanks, Steve, and it's also great to be here on this amazing panel, and good to see you all out there. So can I just first say, I really want to know as an empirical matter whether what we are observing really is striking. I mean, I realize it's striking to us in some part because the cases that are attracting our attention have high political valence. And I think that's part of the story, right? These cases are meaningful, and also they reflect a breakdown of the political process and to some degree a breakdown perhaps even of federalism. So I think part of what's happening is that phenomenon that courts are being deployed in a political battle between the states and the feds, and some courts are more willing to be deployed than others. So I think that's part of what's going on. I think then when you add on the layer of state AGs getting involved, of course it increases the political valence because the state AGs are trying to win elections and also increase their national profile. And I just think the Mass versus EPA standing doctrine has been expanded in ways that probably we might not have predicted. And I don't know that U.S. versus Texas really cuts back as much as maybe, who knows if it cuts back enough.
Not in the Fifth Circuit.
Yeah, right. So that's my first shot at it, but I'm really curious about what my colleagues think is there. Maybe I'm wrong, or maybe there's other things that I'm sure there are other things to talk about too.
Kate, do you want to dive in?
Sure. And maybe on the kind of terminological question, can we call them nationwide injunctions? I think mostly it doesn't matter, but occasionally it does. So I'm remembering you mentioned I was a young lawyer in the White House counsel's office in the Obama administration, and a district court in California issued not just a nationwide, but a worldwide injunction of the don't ask, don't tell policy, while the administration was working to repeal it, but still defending its constitutionality. And I remember, just like a little war story, as like, again, a baby lawyer writing a memo that said a nationwide injunction, and then some senior lawyer said, like, well, it really matters. This is a worldwide injunction because obviously we have military bases, lots of places, don't ask, don't tell is no longer enforceable. The decision, the injunction was stayed. But anyway, so sometimes I think it does matter. And then I think, yeah, the sort of universal or cosmic, I think Mila Sahoni maybe refers to it as cosmic occasionally. Yeah, Gorsuch does, but I think, but I'm not sure who sort of coined it. Anyway, so I think it mostly doesn't matter. You can call them nationwide, but sometimes it does. And, the don't ask, don't tell litigation wasn't brought by a state, right? It was a group of service members or former service members, but both. And so so obviously there's a lot of this litigation that is not brought by states, but certainly the most high salience. And, I think that because of the expansive state standing that Mass versus EPA creates, there has been, I agree, Alex, I haven't seen, I think that, the shadow docket and nationwide injunctions are closely connected, so I don't know, Steve, if you plan to sort of turn your rigorous chops to actually documenting where exactly we are. I think certainly anecdotally, in the last couple of years of the Obama administration, through the Trump administration, and in the Biden administration, we have definitely seen an uptick. But I think it would be really constructive, and maybe folks have crunched the numbers more than I've seen. But I think we're largely more anecdotal than empirical in terms of our assessment of this. And maybe I'll just say one more thing and then I'll stop, which is in terms of what has changed, a lot of when we're talking in particular about state plaintiff cases, it does feel like what has changed is politics. When politics fails to sort of sort out some of the tough questions about nationwide policy, we now have states turning to federal courts as a venue for repressing, seeking to prevail in debates that really should be happening in the realm of politics. So I think that there's kind of a political breakdown and sort of a sense of partisanship story that carries a lot of explanatory power if we're generally right impressionistically that there is something quite new happening.
So, Judge Sands, I don't know that folks would think of the Middle District of Georgia as the focal, in the same way that they might think of the Northern District of Texas as a focal point for some of this litigation. But you've been on the bench for 29 years. I'm curious from your perspective, what's changed in your courtroom, and what have you seen sort of the shifting pressures? I should say, what, if anything, has changed in your courtroom, and to what do you attribute any of those shifts?
Well, let me say this first. Beyond the argument of what do you call this, whether you call it national injunctions or whatever, I was a judge in Southwest Georgia. We have 4 judges in our district, 4 active positions, and except for one division of the court, there's a single judge that sits in each one. And I've never over the years thought about the fact that cases may be coming to my court because someone felt that this was a good court to come to and to get a simple decision. I'm thinking, of course, that plaintiffs come, plaintiffs go. You consider their cases, you decide their case, and you go about your business. But as one of the panelists said in the earlier panel, that seems to have changed more recently. And I've only recently, as I suggested, become aware of it. What we do about it, I'm not certain yet, and hopefully we'll have some discussion about it. But there was, I recall, one little rule in our district, and I should say that we, as judges in our district, we thought having single judges was wonderful because we stayed out of each other's way, in a sense, at your own area. But we did have one rule that's still in place, and I see now that it was probably not planned for the current issues, but it may well have that effect. That is, if someone would file a case in one division, and it's clear that the case probably should be in a different division because of the parties in it and the actual issues, in those cases it was pretty obvious the plaintiffs were trying to find a certain lawyer, a certain judge rather. And in those situations, our clerk just reassigns the cases automatically to the district, to the division where it should have been filed. So this is an issue I'm still learning about and becoming aware of, so to speak. But our district is a large one geographically. We do have a lot of bases and major industry in it, while a lot of it is rural. But I'm much more aware now that when cases get filed, that it may be because a party thinks they're finding a more favorable judge or area than they would have otherwise. But it's kind of it's troubling to me personally.
So I mean, Alexia, you've been involved in this litigation, both representing sort of what we think of as traditional law firm clients and also more public interest pro bono work. Aiming for a judge likely to be more sympathetic, aiming for a court more likely. These are not new developments in civil litigation. So I guess I'm curious, what if anything do you think is different about where we are today versus 10, 15, 20, 30 years ago?
Yeah, I mean, as a sort of a matter of strategy, when you are litigating a case and you are bringing a case, certainly especially in sort of like the public interest realm, but you are thinking about all of the levers that you have at your disposal, and not just what court you're in, but specifically what judge you might be in front of, has always been a trick that you can deploy, marking cases as related that aren't so related, etc. This is really not so different at all. I mean, I think if I even think about sort of my own how these issues have played out and how I would think about them in sort of my own career, which is relatively young but has a very strange element to it, which is one of my first major cases was the Windsor case. And one of my most recent major cases was the Dobbs case. So in a decade, I have been in the federal courts in ways that are like dizzyingly different. And I think there's nothing I don't think like particularly problematic about an injunction or an injunction that would have such an effect. But I think what feels so scary now is the fact that we just have sort of tremendous instability in the rule of law, right? So if we think about, we have this sort of intuition that some of the problems that come up when we're thinking about, what we're calling nationwide injunctions and things that scare us, are when we're talking about law that's sort of, unsettled, right? We have this sort of intuition that it seems much safer to allow courts to move quickly, to not have this percolation, et cetera, on issues that are settled. And we're now in this very, very strange situation where everything is unsettled. Right? I mean, like, there is no more sort of settled legal principle than the right to abortion, pre-viability abortion. And even that is sort of called into question now. And so I think it just makes the entire prospect of these things so much scarier. It makes the idea of, it also, though, sort of on the other hand, it makes the idea of allowing these issues to play out scary as well. Right? Because even on law that should be settled, there's now sort of an increasingly assumption, and the courts are suggesting in some ways that it is unsettled. So I think that is maybe what we're picking. It's sort of the chaos of it all.
So, I mean, it seems like chaos could be coming from one of three different places, or from one or more of three different places, right? One is the remedy, right, that the relief courts are fashioning is somehow more chaos producing or inducing than in the past. One is the judges, right, that perhaps there are some more focused efforts to identify judges who are outliers, ideologically perhaps. But then one, Alexia, to your point, is the actual substance of the law. So no, I want to sort of rope you in on this. I mean, it seems like part of what's happening is also a pretty major revolution in the substance of all administrative law, where 15, 20 years ago, no matter what kind of relief was being sought, the odds that a single federal judge anywhere in the country would have had the substantive justification for invalidating a massive federal program just seem lower. And so I guess, can you talk a bit about sort of some of the forces that might be behind that and where you see those fitting in?
Boy, what a big question. And how much time do we have? I should invite you all to my administrative law class next semester.
You have 40 seconds. No, I'm kidding.
Okay, well, first, just on, I can't resist the history side, because I'm trained as a legal historian. So, Alex, you asked, wait, is this really new? And while I think Kate is correct that I don't know anyone who's actually crunched all the numbers, I do know that as late as Youngstown Steel, the kind of law we're seeing now would have been unprecedented and probably not allowed. And the reason I say that is because if I'm a legal historian, right, I work mostly on the 30s and 40s. If you look back to that period, there was a similar kind of ideological opposition of forces in an attempt to use the courts to strike down a disfavored program. Nobody issues a nationwide injunction, right? You get thousands of individual suits enjoining New Deal administrative laws against individual plaintiffs, but you have thousands of these individual injunctions, no nationwide injunction. And sort of the case in point is even after the war, when you get to Youngstown Steel, this canonical case for thinking about modern separation of powers doctrine, it is not a nationwide injunction. It looks a lot more like the older law that we'll talk more about in just a second, in which you could get a court using its equitable jurisdiction to enjoin the enforcement of an illegal law against an individual person, which is a very different world from the one we're looking at now. So a short way of saying, yes, I think we genuinely are living in a new world. So, Steve, back to your question, why are we living in this new world? Is the chaos about remedies, judges, substantive law? And I would say yes, and the critical and piece is what takes us from more internalist explanations of legal change to more externalist explanations of legal change. The elephant in the room, a well-organized movement that is trying to use the law as a tool of social change, and in particular, a perpetuation of political conflicts that might previously have played out directly in front of agencies or maybe in Congress, but that are now being played out in court. And in pursuit of that project, you have judges whose primary allegiance is to an actual political movement and who see being a judge as part of advancing that political project. So once you have that kind of frame in mind, then the chaos becomes a lot more understandable. So the judges, right? Are we seeing outlier judges? Well, yes, actually, we are, right? Especially in some districts, we have judges who came of age understanding that you could use the law as a judge to really move the law, and that's what they understand themselves as doing on the bench. What tools are they going to use? Well, they're going to seize upon remedies that might have been disfavored under traditional principles of judicial modesty or deference to other branches and use them to advance their political project. Okay, how does the substantive law contribute to that? So I'm an administrative law professor. You have a hammer, everything looks like administrative law, right? I see the nationwide injunction as one piece of this broader revolution in the tools of administrative law to try to empower the judiciary at the expense of administrative agencies. So I put those remedies next to doctrines like the major questions doctrine, or attempts to revive the non-delegation doctrine, or the current challenge to Chevron, all of which contribute to this sense that Alexia said we all have a second ago, which is that many well-settled principles feel like they're suddenly up for grabs.
So can I just one sort of follow-up on that, because I didn't give you enough time. Is that
more airtime for a law professor? Oh joy!
Is that just a function of the sort of external a world in which you had all of those forces, but still fairly rigorous deference doctrines, right? And sort of doctrines that actually were based on the notion that unelected judges should generally defer to the democratic branches. Maybe the Supreme Court could write a famous footnote about articulating this theory. It seems like the deference doctrines were in some ways, if not a defense against that, at least a sort of a dam. And that the real issue then, or maybe not the real issue, but like maybe one of the catalysts of what might be different about the last 5-10 years is that the dam is breaking.
I like that speculation a lot. I mean, I am a law professor, right? I'm not a professor of political science, and so I definitely think that the law has real efficacy. So what work is the law doing here? Well, I do think that the Supreme Court showing its receptivity to certain theories that might not have gotten as receptive a hearing in, say, the Reagan era is part of what encourages judges. So I don't know. The fact that the Fifth Circuit knows that even if it issues a remedy that seems extreme, the Supreme Court will not immediately strike it down under the existing doctrines that might countenance against it, is what gives those judges license to then try to push the envelope a bit. So what are the changes in substantive law that sort of let them do that? Some of them are unrelated to administrative law in particular, or kind of the law of remedies, and have to do with the actual underlying substantive area. So to go back to Alexia, right, when I was teaching constitutional law last year, and I was teaching them pre-Dobbs, but post the Texas SB 8 case, right, how do you explain the refusal of the Supreme Court to invalidate the decision to let this law go into effect? Hard to do if you don't think that they have already judged the underlying substantive issue. So because you know that the substantive law on abortion is changing, the Supreme Court is no longer policing the kind of traditional law of procedure or remedies in the same way. So that's kind of one explanation. But then the other, and this is more like the deference doctrine question, if the Supreme Court is, say, going to be much more forgiving of courts scrutinizing agency action, then lower courts will feel much more empowered to scrutinize agency action. Case in point, even though the Supreme Court has not overturned Chevron, they haven't cited it in a majority opinion in at least 5, maybe 10 years. Certainly the heyday was in the 90s. So you have this moribund precedent that's going to allow judges to look at administrative decisions with much greater scrutiny, knowing they might be able to get away with it. Just one small legal asterisk here, which is that a lot of these APA nationwide injunctions are not being done under the court's traditional equitable powers. They're being done pursuant to a statutory grant or an alleged statutory grant, which triggers a whole bunch of other nitty-gritty legal arguments. Did the Administrative Procedure Act intend to give judges the power to set aside agency action on a nationwide basis? Did they intend to make that the default remedy? Right? That gets us into these delicate questions of statutory interpretation. It's at least worth flagging that throughout the Reagan years, nobody read the APA that way, right? So these conservative judges are now interpreting the APA in a new way in order to reach further, which again strikes me as kind of notable.
Okay, can I jump in actually with
Yeah,
just sort of question or response, and then I'm happy to if there's something else.
I was coming to you anyway.
Okay. Well, so what I was going to say is, the first part of what you're saying, Noah, made me wonder whether, and I think from the second part of what you said, the answer is yes. But what I was wondering was, do the critiques that you were offering in the beginning of your remarks of nationwide injunctions as residing essentially in the same column as the major questions doctrine and Chevron skepticism, and maybe a sort of newly powerful non-delegation doctrine, and sort of obviously relates to the other two. Is that really just about the kind of power of vacatur as opposed to nationwide injunctions more broadly? Because I do think, and this to my mind would be something really constructive, and I don't know that I'm totally clear about it, but figuring out principled lines to draw between the kinds of injunctions that I think that a lot of us are troubled by, where they do feel like they completely incapacitate the administrative state, and that is in fact the point, right? That is the project. So if critiques of injunctions in that spirit can be sort of severed from critiques of the sorts of injunctions that we would want to preserve that are maybe not exclusively outside of the APA context. We're talking about non-statutory Trump versus Hawaii kind of efforts to get a nationwide injunction of the travel ban, which wasn't an APA challenge, and I don't think that's the only salient kind of distinction to draw. But sometimes they do serve important rights protecting functions, right? And so I would like to figure out, in my own mind, clarity between these different kinds of nationwide injunctions. I don't know if that's where you were going.
No, I mean, it is. And then, because I want to get to, this should set up well, but I mean, I guess, and Alex, maybe I can direct this to you for a second, and then I want to ask Judge Sands a question. But on Kate's point about sort of separating good nationwide injunctions from bad, I mean,
that don't just align with our policy views, right? That of course is the critical challenge.
But what I want to suggest is, I actually want to posit that this actually explains the Supreme Court's unexplained behavior over the last 6 years in this space, which is that the court has been hit with a flood of emergency applications from both the Trump and Biden administration, seeking stays of relief properly characterized as nationwide in at least some respect, and various justices, two justices, right, have publicly expressed hostility to these modes of relief during the Trump administration, although they seem to have, lost some of their objections during the Biden administration. But there seems to be no interest on the court as a whole in taking up this procedural remedial mush, right, and in sort of trying to actually hash out when it's okay, when it's not. And instead, the court seems content to let lower courts figure it out, and they'll just step in to stay the ones they don't like and to not stay the ones that they do like, right? Which might explain then why we see certain behavior on the shadow docket. Alex, true?
Well, I think that's true. I kind of want to step back for a second and just think about where I realize the first panel was about, is this a problem? And this panel is supposed to be about, what are the solutions?
We'll get there.
But I can't help but sort of think about if it's a problem, sort of along the lines that Kate was asking. So I think about a case like California versus Johnson. It's not about nationwide injunctions. It's not about an injunction against the federal government. It's about a case in the state of California about how we house incarcerated people and whether or not race can be taken into account. into how we house incarcerated people. It was brought by a single person, pro se. It changed the entire way that incarcerated people are housed, not just in California, throughout the country, because he sought an injunction. He was ultimately successful in the Supreme Court. He also sought damages. And that's a case in which the rights of non-parties are being adjudicated. And this is typical. Like, this is not new for us, right? There's nothing new about courts deciding the content of constitutional rights and it having application beyond the scope of the particular plaintiff in front of the court. And so one question for me is, okay, is that different from the kinds of ways in which we see nationwide injunctions being deployed here? Is it different because of who the plaintiffs are? Is it different because of the nature of the claims being brought? Is it different? Does it matter that we're talking about feds versus states? Frankly, I actually don't know that I think it matters that we're talking about feds versus states in terms of who is bound, but maybe it should. And so to Kate's question, and to your question too, Steve, I think, yes, the court is acting in a way that it seems to it's not giving us any clear picture of what it thinks about the propriety of this from a procedural perspective, and it's all being expressed through their own preferences, I think, as to which policies they think are bad and which policies they think are good. That's a terrible thing. Like, that's a bad thing, right? We don't want a procedure that looks like that. But it still begs the question of, how do we draw the line, if we're inclined to draw the line, between certain kinds of injunctions that benefit non-parties and certain kinds?
I'm getting there.
Okay.
So that's two questions away. But I want to bring Judge Sands back in for a second, because, I mean, Judge, part of what we're really sort of hammering out here and fighting over is the relationship between the Supreme Court and lower courts, right? And the sort of the different role that lower courts might envision themselves playing vis-a-vis courts of appeals and the Supreme Court. I'm curious, just from your experience, how you would go about thinking about that. Like, you are a district judge, you are master of your courtroom, but you have a court of appeals and the Supreme Court above you. When you get a case that might have implications beyond the two parties in front of you, how do you even think about that?
Yeah, I would be concerned based on what I've heard said about a projected from different members of the panel saying we're at a place we've not been quite before. As a trial judge, what I want to know is this a case that's properly before me? Is the party who's bringing the case one that can bring it? So I'm looking for things either from the Supreme Court or my appellate court that help me to instruct me in that way. Because what I've always been concerned about as a trial judge is, is everybody who's coming to my court getting the access that they should get, and are they being disposed of the way they should be? This idea of judge shopping, what I thought judge shopping was before this current situation was, well, can you get before a judge that will at least look at your case? That was what you call, that's what judge shopping was. But now to think of someone brings a case in my particular court because they not only think that they get a favorable consideration, but they can predict its outcome because of something they think that they believe they understand about my thinking or about philosophy. I think that is troubling for the court, judges, and for the nation if we become that in fact, which is highly suggested by some of the comments here. When I came here on yesterday, I got a cab because I recently signed up for Uber but didn't finish the process. And the cab driver, asked me when he got the address here. He says, are you a law professor? So I kind of said, And I was so,
you have a real job.
Right. I was so glad that I did not say no. I'm a judge. Because what he said to me, he had this case, and he says, I'm really upset, He says, it just doesn't, it matters which judge you get, and what that judge thinks and what that judge wants to do. It has nothing to do with the law and the facts. And he said, as I got out of his cab, he said, I will have nothing else to do with the legal system. It says, if I get called as a juror, I will just say, I don't believe in the system. And that was so disturbing to me as a judge that this person perceives the system that way. And I think part of what's going on now, whether it's actually true or not, is a perception that the Supreme Court believes a certain thing and decides when they see that way, or certain appellate courts do, and certain judges, if there are such things, outlier judges. When I first came on the bench as a Clinton appointee, a professor did a survey and they looked at decisions by district court judges, and they found that there was very little predictable difference for rulings by district court judges, depending on which party appointed them. I don't know whether that's the case now or not. I'd be interested in seeing whether or not that more recent appointments have more to do with other reasons other than just competency, and therefore there might be some predictability in that situation. But it is very disturbing to me that we could not consistently allow access to the court system and it be decided definitively on legal grounds and not on personal grounds. So what concerns me is, can I get the direction from the Supreme Court that helps me do that appropriately as I believe I should do it? I will say for our circuit, though, our circuit is taking a position that there should be some limiting of these types of injunctions, acknowledging that there are situations where they should be applied, but that maybe we should be more circumspect as how broadly they be applied.
So, Alexia, to the point about guidance from the Supreme Court, and especially guidance from this Supreme Court, right? We are in this sort of fascinating. Where you stand is a function of where you sit. I sit in Texas, right? The Fifth Circuit is very quietly having the worst couple of years that any court of appeals has had in the Supreme Court since the Ninth Circuit in the mid-2000s, when there was a much more obvious reason for that disparity. We just saw twice last week the Fifth Circuit got shot down by the Supreme Court through unsigned, unexplained orders that nevertheless I think had a quite obvious message underneath them. I guess my question for you is, maybe wearing both of your litigation hats, isn't that enough? Right, that's like, if the Supreme Court is, reining people, if the Supreme Court is sort of taking a Goldilocks approach to when these cases are getting out of hand and when they're not, is that sufficient? What might sort of not be enough about that reaction from the court?
Well, I think historically the at least belief that would happen has sort of been enough, right? I think that's part of why we're all observing that though there's been a sort of proliferation recently, like it's not an entirely new phenomenon. The idea that you would have such a, form of relief is not, totally outside the bounds of what we would sort of think is okay. And I think part of what has kept everything in line has been the belief by actors at sort of every level, including like the state AGs, that would be enough, and sort of the Supreme Court would be a guardrail on all sorts of things, including like, legislators, I think, have been sort of reined in by the belief that, generally speaking, they're not going to go past sort of blatantly unconstitutional laws because it's sort of the Supreme Court's going to step in. And so the one question, I suppose, is it really what they're doing now? If it were, I think it would be close enough to enough, perhaps. But I don't think that the current state of play, even though the Fifth Circuit has been sort of chastened in a few in a few isolated.
They may not know that.
Yeah, exactly. Right. They've not been chastened. I don't think that it is actually enough because we are seeing so many things sort of get through. And the SB 8 example is such a great example of something that just absolutely emboldened actors at absolutely every level, again, including sort of like legislators. So it would be enough, but it's not really, perhaps, but it's not really the case, I don't think.
So no, I want to sort of bring back in the historical piece of this for a second. One of the, I think there's some loose familiarity, at least among lawyers and law students, with FDR's court packing plan. I think there's less familiarity with the part of it that actually was implemented by Congress, which was reining in the power of individual federal judges to block federal laws, right, on constitutional grounds. That this is one of the things that Congress does in 1937 is it actually expands the jurisdiction of 3-judge district courts, right, which had been sort of first really brought in 1910 to deal with federal judges and state laws. Now we're also reining in the power of individual federal judges to stand in the way of entire federal programs too. I'm curious, historically, do you think there was a similar set of provocations for that reform? And as we turn toward sort of questions about what we could do to fix the problem, would 3-judge district courts be one place to start?
God, I want to sit in on your class, Steve, on the history of federal jurisdiction.
I grade on a curve.
That will be necessary for me, honestly. Okay, let me take the question at a slightly higher level of generality, since the particular 37 reforms, the key piece that I would just want to underline about what Steve said is that at other moments in American history, political actors have understood that there is tension between the judiciary and some of the other actors in politics. A small pet peeve of mine is when the court refers to the political branches as if it is not a political branch. Of course, there are 3 political branches. Another little pet peeve of mine, this is outside the scope of this panel, nowhere in the Constitution does it say that there are 3 branches. There is no separation of powers clause. People who say that are trying to sell you something. But that's a separate story. So, okay, right, in moments when people have understood that the judiciary is a political actor and they want to try to rein it in, they have not been shy about deploying different tools. So it precedes 1937, right, all the way back to the very first peaceful change of power in American history between the Federalists and the Republicans in the so-called Revolution of 1800. On their way out the door, the Federalists try to stack the judiciary to keep their people in place. They create new courts, a major successful court packing plan. What do Thomas Jefferson and the Republicans do? They eliminate one of the existing circuits, and they cancel the Supreme Court term. And Justice John Marshall allows the term to be canceled because, in fact, the Constitution is unambiguous. Congress has the power to specify the Supreme Court's appellate jurisdiction, specify when and how it will meet, and all that jazz. So forget about court packing. You could cancel the Supreme Court's term if you wanted to, and the results in 1800 were the same as in 1937, by which I mean the threat of more severe action was enough to discipline judges. So when Marshall comes back, he knows that depending on how he rules, he might endanger the entire legitimacy of the court, and so a Supreme Court dominated by Federalists tacks a course not to further antagonize the majority sentiment of the company, which is Jeffersonian Republican. After 1937, the threat of court packing contributes to internal developments at the Supreme Court to change its own jurisprudence. But, as Steve is alluding to, there are a bunch of other procedural tools in place as well. So the 3-judge panels, a mainstay of 20th century American jurisprudence, especially but not exclusively seen in the voting rights context. The idea was that you wanted some kind of mechanism to prevent individual rogue judges from disrupting governance. And just to be clear, that was explicitly on the mind not only of Congress, but also of Supreme Court justices. So Abe Fortas has this great dissent where he says, we really have to worry about individual district judges with the power to invalidate federal law. My God, there are so many individual district judges. So I like 3-judge panels, but more important to me than 3-judge panels is having some other form or just any form of centralized review. So you could use other channeling statutes, right? You could just send them all to the DC Circuit. We can also look to other countries. So I recently wrote a paper in comparative administrative law that looked at the Conseil d'Etat in France. There, if you have the possibility of invalidating a nationwide regulation, it goes directly to the Supreme Court right away, and you could even bring a pre-enforcement challenge to it. Since, and this goes back to Kate's point, we're not really talking, at least in my world, the administrative law world, about equitable powers. It's a statutory issue, and we know that you can bring pre-enforcement challenges under certain statutes, right? It doesn't raise a case or controversy requirement. I don't think there's anything stopping some kind of a channeling statute that might bring a preliminary hearing and then an immediate appeal to the Supreme Court, which is basically how the 3-judge panels worked.
Right. I mean, the reality is that from 1910 until 1976, right, there was direct mandatory appellate jurisdiction in the Supreme Court from a 3-judge district court's grant or denial of a preliminary injunction, right, which was a pretty remarkable thing. So, I mean, I want to get to the broader conversation about Congress. Remember them. Back when there was a House of Representatives that was legally constituted. But before we do, I mean, I guess there's a broader question here, which is, I guess I still hear some ambivalence maybe across the panel about the extent to which where we are right now is a problem, right? Or at least what the problem is. So Alex, let me sort of put this to you. Insofar as you think there are structural issues pervading contemporary, right, civil government accountability litigation, besides all the ones you and I encounter with how impossible it is to get damages. But just on the injunctive side, I mean, like, where do you see the problem is lying most forcefully?
Well, so I mean, there's a lot of ways to answer that question. When you say the problem, do you mean the problem that we're talking about here today?
I meant it. I was open-ended on purpose.
Right, because there's ways in which, like in the world in which I live in, and I think to some degree Alexia lives in, and you too, Steve, like to get relief for our clients is so hard. I mean, whether it's damages or injunctive relief, there are so many barriers to the kind of work that I do that makes it challenging to obtain relief, let alone to get a nationwide injunction, right? I'm not even talking about that. I'm just talking about whatever, getting medical care for an incarcerated person or for a group of incarcerated people. So if the problem is standing doctrine, like if to some degree the problem for me is standing doctrine, and the reason we're seeing a rise in broad injunctions is because of broader standing doctrine for certain kinds of players like states, well, look, honestly, we could stop now because we're not going to do anything about that. That's going to be up to the court to decide that it wants to have a different standing doctrine, and nothing we say, I think, is really going to do much about that. If the problem is we've got rogue judges and it's too easy to forum shop for them, well, we could imagine lots of different ways to deal with that. We can't get rid of rogue judges. We're not changing the way judges are selected or who selects them. But like, could the judicial conference say division of business now within a district is actually something we care about? And so we're going to...
It said this last week.
Right. We're going to do something about the rules regarding division of business within districts, and we're not just going to leave it to the districts to decide how to do it. Well, that's and then we don't even need to talk about Congress. You know, if we think the problem with what we're talking about here from a procedural matter, maybe substantive, is both the breadth of the remedy, the fact that these cases are often decided on thin facts, the fact that we don't get percolation when we have an injunction that bars the federal government around the country. Well, I don't know that three-judge district courts are actually going to solve that problem. I don't know that three-judge district courts with immediate appeal to the Supreme Court will solve that problem. It might solve other problems. It might solve judge shopping. But I would just add, I would say, as long as the parties are blind as to who's on the panel until they show up to argue,
or circuit style,
right? Yeah, or DC circuit style too, right? You learn like really, really close to. Anyway, so I mean that then we're getting somewhere. So I think that it comes back to what we think the problem is, how we would respond to then that affects how we would respond to the problem. So it's like whack-a-mole a little bit, right? We're gonna try and solve it in one way, and there's always strategic behavior by litigants. So the question is, how much room is there for strategic behavior?
So I guess, I mean, Kate, let me sort of put this to you. I mean, so there's a common theme in almost everything that, right, in almost all the vectors you just sort of laid out, which is courts doing it on their own, and courts, leaving courts to their own devices. For example, right, the idea that it's the judicial conference that's going to fix judge shopping when it's actually a statute that delegates to district courts the power to do it in the first place. So, Kate, let me ask you, if there is a problem or a unifying problem here, is it possible that it's the complete absence of Congress? And the fact that for the better part of the last 35 years, the federal courts have been left entirely to their own devices to do all of this?
Yeah. And maybe to step back just for a second in terms of is there a problem? I think yes, definitely, and this is implicit in a bunch of things that have been said, but just to say it explicitly, the kind of combination of highly ideologically motivated state attorneys general and state solicitors general, relatively new position in a lot of states, combined with very, sort of precision judge shopping, which can happen, and then very highly ideologically motivated some, certainly not all, but district judges. And you have a scenario in which you have red states finding sympathetic judges, and obviously, I think it's been all Trump or Republican-appointed judges that have at the district court level at least voted to invalidate major Biden administration initiatives. It was not exclusively, although it was largely Democratic appointees at the district court level invalidating Trump administration policies. It was a little bit more, I think, ideologically or appointing party mixed at the Court of Appeals level. But you both have that as a substantive problem, and I think as a kind of perception problem with respect to the public's understanding of courts and what courts do. And so, yes, I think that is largely, I think, a critique that is limited to the state plaintiff context, but I think a very real one. So just wanted to pull those threads together since I'm not sure I did. Yeah, Congress has been completely absentee. I think that's right. And as your book, Steve, so eloquently demonstrates, I mean, the court has stepped into the gap more than, we're talking about going, back to Taft in many ways, not just the last 35 years, and something that, Noah's written about Taft as well. So this is not, I don't think, that aspect of it, sort of congressional abdication maybe in recent decades I think is not too strong. I'm not sure if that's true for the entirety of the last century, but certainly in recent decades. And courts have been delighted to fill the gap and assume for themselves both kind of outsized power across a number of different domains, but sort of agenda setting is one I think you write about so incredibly effectively, Steve, in your book. But so I don't have the answer to the kind of question of what, is Congress to blame? I think yes, I definitely have the answer to that question. What should Congress do, I think, is harder. But I do think that there's just lots of social science literature on multi-member bodies serving as sort of moderating forces. And I'm not sure if 3 is the right number, honestly. I think in some ways the panels of the Fifth Circuit potentially refute the idea that just 3 is going to be enough to sort of reduce the incidence of pretty lawless opinions. So maybe 5 or 7 would be the right number. There's nothing magical about 3. We just sort of have the tradition of it. But I do think a multi-member body assigned the power to hear any matter in which you could define it in lots of ways, but where a nationwide injunction is sought, and in the first instance, I think would work as or some kind of immediate as of right appeal to the Supreme Court. I think would work too. But I do think a multi-member body to hear in the first instance a much broader swath of cases than the largely just election-related disputes that go before those courts today would be a good start.
So, I'm sorry, Judge.
Yeah, let me just say, district judges are fiercely independent. So I don't know how cooperative they will be giving up some of that independence as suggested. I think there may be some value to the 3-judge panel, but I don't know whether that really solves the real problem, because to the degree that you have 3 judges or 2 or 3 judges who, if they are outliers, individually, or if they do see it as their role to supplant, others in their decisions, I don't know that would do it. In other words, that you're kind of presuming that you're going to have independent thinking people of different viewpoints. But I think with what's happened more recently in appointments, to the degree they've been more political or more ideological in terms of the selection, I think that puts whether 3 judges would solve that problem into question, particularly where you, again, have the smaller districts with a handful of judges. And I want to say, too, when I used to go to the National Meeting of Chief Judges, and what I found out was, unlike the Southern District of New York or the Eastern District of New York or Detroit or Los Angeles, most federal courts have about 4 to 6 district judge positions. The average district court looks more like my district than it does like the Eastern District or the Southern District of New York. So that idea, when you're selecting from 10, 12, or 15 judges, that makes sense. But the smaller the districts get, the less likely that using a panel will work, particularly if there's not a true diversity in the judges who make up those courts.
And this is, at least in Texas, this has historically been the historical defense of single judge divisions, which is just that you have district courts that are very physically large, and that it's much more efficient for the lawyers, the judges, the parties to have them be geographically divided as well. That's in an era when we had jury trials, that argument might have been more persuasive. No, I guess you already disavowed being a political scientist, but I want to ask you what is, I guess, a political process question, which is, we might all not agree on where we'd start with things we'd like to see Congress do to the courts. Alex and I might start with, qualified immunity and codifying Bivens. But it seems like there's a broader problem, which is even persuading Congress that anything is something it should do in the first place. I don't mean this as an indictment of our current political moment, because this has been true of the courts since long before, right, the last 10, 15 years. And so I guess I'm curious, just from the historical perspective, what was it about the Jeffersonians versus the Federalists? What was it about, Democrats in Congress versus FDR that created the political circumstances for meaningful, congressional, I don't know, pushback, but sort of engagement, right, in the work of the courts in those prior episodes?
It's a great question. I think that when interests have organized politically around the judiciary, then you can get legislation and so political change. So before the Jeffersonian Republican story is pretty explicit, right? It's the Jeffersonians come in, they find that their political opponents have seized the courts, and so they push back against it. In the 20th century, it's a little bit of a more mediated story. So I'd say the first real organized effort to redo the courts came during the progressive era, when there was a real sociological difference between the courts and the voters. The courts, the federal courts, were really dominated by big business lawyers who were very hostile to labor, but both parties, especially the wings of the parties that were dependent on voters coming from cities, so the Democratic and Republican political machines, they had a lot of support from working people. And so you see labor unions who make opposition to federal courts a key plank of their organizing, and that leads to some of the first campaigning against things like the labor injunction, right? From very, very general principles, we're going to build worker power, to like a really concrete technical judicial reform. We're going to fix the way judges issue labor injunctions. Something similar happens in the 1930s, right? It's because federal courts are perceived to be hostile to the New Deal that you then start to get an organized interest looking for judicial reform. Although, of course, this gets more complicated because as Roosevelt pushes judicial reorganization, he's perceived to be exceeding his power. This is an era when there's a real fear of executive overreach, right? It's the mid-1930s. You don't have to look very far to see some dangerous examples of executive empowerment. And you also have the rise of the conservative coalition in Congress, which is concerned about a too extensive New Deal, so that mediates the reform efforts. But what does that mean for us today, right? I think the reason we haven't seen congressional action is because, perverse as it may sound, the current arrangement must be serving Congress's interests. And we can look at the pathologies within Congress such that we can say, wait, how could it be serving Congress's interests if it's not serving the people's interests? And that's a much bigger question. But if we say, oh, wait, reform doesn't serve Congress's interests right now, then we have to start asking ourselves, well, what might make it serve Congress's interests? And just to switch tacks for a half second, in my introduction it was mentioned that I do a lot of work related to New York State courts. And in that capacity, I have been surprised at how New York State legislators who've been very organized around certain issues, especially criminal legal reform, just didn't realize that the payoff of those reforms depended in a really immediate way on who the judges were. And that was a process of public education. We had to educate our representatives and say to them, wow, if you care about mass incarceration, it's not enough to just pass laws that change bail conditions. You actually have to worry about who the judges are who implement those laws. Okay, I suspect that we might need to do something similar with Congress. It's not true for all of Congress, right? Republicans in the Senate have long understood that part of realizing their policy program turns on vetting judges for ideological conformity. And that's a whole story about how they read what it meant that David Souter was such a principled judge and how offended they were by Judge Souter's principles. But that's a story for another day, right? I do think that if we want to try to push any of these reforms, the first thing we have to do is help Congress understand, both Democrats and Republicans, that regardless of their partisan positions, it's bad for American democracy to have the judiciary operating this way, and we should be suspicious of the judiciary's ability to police itself, because any meaningful reform will require some of these independent judges to give up some of their power, and it will definitely require the Supreme Court to give up some of its power, and powerful judges with life tenure are not going to be excited to do that.
So on the pushing judges to give up their power, I mean, Marshall's great, I guess, move, I'm not going to, genius is a little strong, but move, right, in Marbury is to take power by giving up power. Right, or give up power by taking power, depending on how you orient it. Is it possible that there's a similar? I mean, let me just give you one example, right? So the Supreme Court's docket today is almost entirely discretionary, right? The 57 of the 58 cases the court decided last term were through its cert docket, where the justices had the power to choose which cases they heard. Would, hypothetically, Congress bringing back more of the court's mandatory docket in cases Congress wanted the court to decide, but the court didn't? Is that taking away the court's power by giving it more to do? I mean, is that sort of something that's in the water or should be in the water?
I love it, sure. I mean, if we're going to go down this road, how about we get the judges back to riding circuit, too? I think... But no, I take your point. I think that's right on the money. And maybe I should be clear here that when I'm talking about power, the judiciary clearly plays a really important role in American life. And I think it's easy to caricature people who are calling for a reorganization or reform as folks who don't believe in the rule of law or are looking to destroy this hard-won commitment to judicial independence. That's not it at all. And the kind of reform that Steve just proposed, something like asking the court to operate more like a court and less like, I don't know, a super legislature, is exactly an example of the sort of reform that ultimately, I think, reaffirms fundamental values while making it more difficult for them to operate in this ideological way. I do think it's worth returning to Alex's answer to your first question, which is, wait, what is the problem, right? And I think a reform like that could help solve a problem, which is greater ideological orientation, maybe broader than just the injunction question. But I would just put another little thing on the table while we're talking about what the problems are. It strikes me from my position that one problem with the situation we have is it's sort of the opposite of the percolation problem. Mm-hmm. It's that you can have you can invalidate government action so quickly and then take so long to reach a final decision that you essentially incapacitate the ability of the government to operate. Right. And so solving that problem, right, through centralization might exacerbate a different problem, which is the absence of percolation. So actual solutions here are genuinely non-trivial, but creating the political conditions for those solutions, that's something I think we can all agree on.
So that's my question. That's what I wanted to ask Alexia. So, I mean, Alexia, you've been involved, obviously, in grassroots work that has been very popular democratically and work that has been maybe somewhat less popular democratically. Mm-hmm. How, for those who think that that Paris is worth this mass, right? Where do you see the groundwork starting?
Yeah, I mean, it's really interesting because it strikes me that one of the sort of problems that emerge from doing so much important sort of like public decision making this way on these big issues of public importance is actually that it is increasingly taking what are like very practical, real-world effects of these laws on people's lives and making them more and more abstract in all sorts of ways. Whereas sort of like if you think about sort of traditional, like impact litigation along these lines, sure, like ultimately at the end of the day, you hope that you have a decision that then you can be applied to all sorts of people. But really it's about like individual plaintiffs and individual stories. And so much of how this is playing out, going the injunction route, where it's going to be incredibly expedited, so you don't have sort of the same fact-finding, of course, and sort of development of the record. But even if you think about like sort of like who the plaintiffs are, right? If like states are the plaintiffs, like states are not people, and like they really don't make these cases about the people, mm-hmm. right? And I think like certainly like if you even think about sort of like for example the tremendous expansion in a very short period of time of rights for LGBTQ people, so much of that was because it was finally sort of not an abstraction, right, but about sort of people's actual lives. I think so much of like the magic of like the Windsor case was that we had one plaintiff. She was a lovely old lady that had like a relationship that like once you heard anything about it, you're like, if that ain't a marriage, like, I don't know what is, right? If we had done, if the Windsor case had been one of these sort of more of like a, a nationwide class action or nationwide injunction, sort of like, we would have a very different sense of how these problems play out, and the public would have a really different sense of how these problems play out. And I think, actually in the abortion context, one of the big problems we've sort of had in terms of people sort of understanding of the issues and opinion on the issues has been that we've litigated them at this level of incredible abstraction. Like, what is choice? Who's right? Where is life, etc. As opposed to, no, like, here is the effect of this right playing out in like a person's life. So I mean, I think one of the sort of problems perhaps that we should be trying to solve for is the extent to which we're allowing this litigation to be, sort of moving farther and further away from people and lives and a public understanding of how unconstitutional laws actually like affect real people.
So, I mean, I agree with all of that. Can I push back in one small respect, which is 303 creative, where the individual plaintiff was not just front and center, but an artifice of the individual plaintiff was front and center in the case. I mean, does that give you pause at all, or is that just about better fact finding and fewer dumb stipulations by the state in the trial court?
Yeah, that does not give me.
Fair enough. So, I'm sorry.
It's also true that you can have Ms. L, which is a nationwide injunction class brought by the ACLU about family separations, put people's experience front and center. I mean, right? That was obviously part of the strategy.
But there's
but I think Alexia's exactly right that because we have this expansive understanding of states and their ability to claim an injury that is extremely abstract, they're able to litigate those cases where that's the story.
But not just abstract, but also where the story is the politics of it.
Absolutely,
as opposed
right?
to the plight of an individual.
And it's explicit, right?
Yeah.
There's no. That's what's
when Ken Paxton was being impeached, right? His principal defense of why he shouldn't be impeached, besides because it's Democrats in the Texas legislature, which was a funny thing for him to say, right? Was someone's got to stand up to the Biden administration, and if not me, who?
Yeah.
I'm like 26 other attorneys general. Kate, let me ask this question to you. I want to provoke you a little by saying something nice about the Supreme Court. Right? So I sort of alluded to this before, but there's a way in which you could look at some of the Supreme Court's behavior in the last year and a half as maybe reflecting a little bit of buyer's remorse on the part of at least the three justices who, for lack of a better word, I'll say are in the middle of the court, not the median, or the median, but not the median, but not the political middle, right? The Chief Kavanaugh and Barrett, where maybe having sort of hit the big ticket items and the red meat items on the conservative legal movement's sort of wish list, I guess. Some of the stuff that they're seeing coming out of lower courts now is actually worrying them. Even if they're sympathetic on the to the merits on the bottom line. Do you think that that's a remotely fair descriptive account? And if so, do you think it actually is something that is should give us at least some faith that the wheels are not totally falling off?
I think there are seeds of it. I mean, I think in terms of on the merits docket, obviously, Allen versus Milligan, the Voting Rights Act case, Burkeen versus Holland, the ICWA, Indian Child Welfare Act case, right? There are places where those, median or justices did pull back, or at least some of them did. And then I think some of that on the emergency or shadow docket, in the last couple of weeks as well. I just think it feels a little too soon to tell, and I also think that some of what has proven too much for at least Kavanaugh, Gorsuch, and Barrett, or Kavanaugh, the Chief, and Barrett, depending on sort of the issue, has been so extreme that it's sort of, I'm just not sure buyer's remorse is right, and that I'm just not sure they even thought this sort of exceeds anything they could plausibly have understood them to be themselves to be buying or sort of laying the foundations for. So I think maybe they haven't really changed course much, and the Fifth Circuit has just gone so fast and so far that I don't want to mistake what we're seeing at the court as a real change in anything that the court thinks or is doing so much as increasingly outlandish behavior by judges. Again, not just in the Fifth Circuit, but it really is a pretty stark kind of how many of those of the real outlier opinions come from the Fifth.
Well, but those things are related, right?
Yeah.
I mean, like the reason why we're seeing such a constant. I mean, I get journalists all the time who say, "Why do you think there are so many cases coming out of the Fifth Circuit?"
Yeah.
I'm like, "Because there are so many cases going to the Fifth Circuit,
Right.
That when litigants are able to bring a nationwide challenge to the FDA's 2000 approval of mifepristone in Amarillo, right? When every single immigration policy can be challenged in Texas, not on the ground that Texas abuts Mexico, but on the ground that Texas suffers a pocketbook injury from the sort of de minimis cost of additional law enforcement. I mean, I think,
Or driver's license back to
Oh,
to DAPA. I mean, these injury claims are so strained. Sorry to interrupt. Go on.
No. So because I wonder. I mean, this Supreme Court term, right? Sort of, folks who spend their time thinking about terms holistically try to find themes, and it strikes me that one of the themes of this term could end up being we're not as crazy as the Fifth Circuit, right? Which may not tell us how crazy the court actually is.
Yeah.
Right, but might still be sort of and indeed might actually be useful if you're Chief Justice Roberts to have a term like that.
Completely, yeah.
But I wonder, sort of, as we who write about and talk about the court, what position that puts us in.
Yeah, I mean, so we dropped an episode. So we were out doing a live episode of my podcast in Austin a couple weeks ago. We actually dropped the episode this morning, and this is sort of a big. No. It was like you were here, but it was that's a sort of a big theme. Is that the court actually, I think, very likely will push back on the Fifth Circuit in at least a few cases, and maybe more than that. And yet, I think that tells us more about the Fifth than about the Supreme Court. And I actually think that the CFPB case, a lot of, I think, commentators coming out of that argument thought that there were maybe 0 votes for this appropriations clause challenge, and I didn't think that was the case at all. I think it's even if there are repudiations of the Fifth, I think they're going to be narrow and closely divided. I don't think there are going to be a lot of kind of 9-0 kind of smackdowns. And maybe just one thing on the kind of both on the I think both on the general kind of nationwide injunctions question when we think about reform and maybe in terms of sort of where we are with this Supreme Court at the moment, you just have any kind of reform question. You have questions about sort of false positives and false negatives and sort of which is a bigger problem, right? That the empowering lower courts to issue these injunctions, resulting in a lot of them being issued where they should not rightly be issued, and then over curtailing those abilities, resulting in problematic negatives. False negatives is probably the wrong way to describe it, but removing a power that actually is really important in some contexts. And I mean, I guess I'd say. I certainly am not, at the moment, I think that I guess I trust the Supreme Court more than I trust your average random panel of the Fifth Circuit, which is not exactly your question, but I think that's right. And so their, kind of stewardship of the Fifth Circuit, and of lower courts in general seems to me, I think, on balance, in part because of some of the seeds that you reference, to cash out as a good. But I think it's close. And I also think it's really important that we kind of come to some consensus that does try, to a degree, it's not ever going to be fully possible, but that tries to be, to limit the degree to which our response to any particular intervention by the Supreme Court tracks our intuitions about the underlying policy the administration is pursuing.
No?
Just a quick comment here on the temporal horizon, right? So the Dobbs decision was incredibly unpopular and politically costly for the Republican Party, and John Roberts knew that, right? He did not join the majority. He had his own concurrence that was trying to narrow the opinion, and I think he was vindicated as a partisan political actor. As the Supreme Court has moderated, it can reliably get good press coverage that will say, look at how moderate the Supreme Court is. No one is ignorant of the year that we are heading into. And so if you are interested in achieving a conservative policy program and you control the balance of power in the Supreme Court, you do not want to go into the 2024 election cycle with lots of newspaper articles saying rogue, out-of-control Supreme Court dismantling the administrative state. You want headlines that say reasonable Republicans in control, worst predictions of crazy socialist law professor at NYU proven false. Don't worry, the adults are in charge. John Roberts has that luxury. He's a young man on the court. I mean, not a young man anymore, but compared to the age of judges, he can look forward to many more years on that court. The only threat to his power is overplaying his hand. So my position on this is that we should not make the mistake that political commentators do in looking at the Supreme Court. We need to think about the horizon of its actions. And against that backdrop, it's exactly what Kate said, right? The danger here is a structural danger that we need to assess very delicately because there are good things about being able to issue nationwide remedies. We can't throw the baby out with the bathwater, but we need to think about that independently from what the Supreme Court happens to do any given year because, as was said in the 1930s, the court follows the election returns. So in light of what could be a real threat to its power, it will moderate its actions without addressing the underlying structural problems.
So, Judge Shands, I want to send one more question your way before opening the floor to the audience. You're surrounded by law professors and one practicing lawyer who's above it all.
I'll take the upgrade.
And I guess I'm curious. I mean, what aren't we doing enough of, right? When it comes to sort of public education, public awareness of some of the issues that we've touched on today. You see this from the other side of the bench, right? I'm curious, like, what more can be done just to increase public understanding, public awareness, even maybe judicial understanding on some of these issues?
Well, I think forums kind of help, but I think each case, in a way, when they're filed, serves as to give some exposure as to the way things are, the way they're thought of. And I've been really pleased with what I heard both of these panels that helped give me some guidance. But for a trial court, it's very difficult to react to things in the way that's been talked about here. And I think part of what has occurred is that partisans have discovered that what they cannot receive in a purely political atmosphere by going to the legislature or going to Congress can, in effect, sometimes have a pretty good chance of being obtained because the court doesn't have the choice. I used to say to people, they said, these liberal courts, these courts are out of control. They're doing these things. And I say, no one stands on the courthouse steps waiting for plaintiffs to come. Please come and file a case. So to some degree, it's the parties who are determining what is being filed. What I see from practicing lawyers is, as I say to my clerks, often now they're very bright lawyers who are very well prepared. There's a very well selected plaintiff or plaintiffs, and the case is presented in an understandable way so the court actually knows what its choices are or what are the guide rails. But there's a lot of litigation that are brought by people who think they're getting on the most recent popular bandwagon, who don't bring cases carefully thought of, who are not particularly astute in what they are doing. And those things make it very difficult for the court. So I'm hearing here there are things that the legislature can do to help the court. There are things that the Congress could do, and some, I guess, for federal courts could do to help us. Obviously, the Supreme Court can do so. And some of the circuits, as I said earlier, our circuit has given some guidance. They've dealt with a number of these cases, and they are saying, we do see there's a need for these in some situations, but there needs to be some curtailing or circumspection from the court. So as I said earlier, there's a problem that I didn't know was a problem, but I've become more aware of. And I'm concerned that we get the kind of assistance both from within the court system and perhaps from outside of it that helps us do it. I see that it is something that's important. I would hate that a plaintiff of a true matter could not get it before a court because there's no access. But at the same time, that we are not having judicial ideologues, being more concerned in imposing their own political ideology than really addressing it as a legal matter. So that's a long answer, but
No,
that's my thoughts.
spot on. We have a few minutes, I think, before lunch for questions. So I think there's a microphone. Start here, and then I'll come back to you.
Thanks a lot. A terrific conversation. As a member of the public who is fully in sympathy with that Uber driver who gave Judge Stevens an earful, I've got a suggestion based on my own litigation, where I've discovered that instead of adjudicating parties' argument, judges adjudicate their own. They simply replace parties' argument with judges' own sus splendid argument. And what is the easiest way of being ideological and deciding for your own argument? So I sued judges for fraud, a bunch of judges for fraud. The DAs who defended them argued that in Pearson against Dre, judges gave themselves the right to act from the bench, quote unquote, maliciously and corruptly. So their position essentially is, you've been treated fairly, corruptly, and maliciously. And incidentally, one of those cases was in the court of Judge Garofis, my case against Judge Eric Italiano, and Judge Garofis said that in his decision that such substitution of argument is quote unquote classic application of judicial function. So, and my solution to this whole problem is to add sua sponte argument to the criteria of judicial misconduct, because it is very, very clear to me at least, and I think to everybody else, that a judge cannot possibly have standing in his own courtroom acting as a party to the case, which is what the lawyers do. That's what lawyers are for. And I've advocated this in a book I wrote based on my experience titled, Why Do Judges Act as Lawyers? A Guide to What's Wrong with American Law. And I'm really, really curious about your ideas on banning sua sponte argument and making justice look the way it looks in this, Lady Justice thing where there is plaintiff's argument in one tray, defendant's argument in the other tray, and, whichever way it goes, but judge's argument is in neither tray. Thank you.
Well, could I?
Please.
Go first. Well, of course, I think that what you speak of, the idea of judges making the case their cases, which is what I hear you saying, is generally inappropriate. But I must say, as a trial judge, sometimes parties who, again, come in very prepared will ignore obvious arguments, obvious matters that bear on the case, and they're trying to get around it. And but it becomes a matter that's clearly plays a role in deciding the case. So the method that I use to keep it from being something that I would sua sponte raise without the parties' participation, I'll just say the court notices that in this issue of motion raised by X, that neither party discusses the issue of so-and-so. And the court believes that issue plays a large role in this case. So please brief me on this issue. You may have 5 pages and there will be no replies. And what that does is it forces the parties to address an issue that the court sees as maybe even dispositive of the underlying matters. But I do agree with you in the general sense that the court should not be, if particularly civil matters, if a party is not smart enough to raise their issues that support their cases, then they don't get raised. And so I regularly see cases that are lost because the party, believe it or not, there are lawyers who have not heard about Iqbal and Twombly. and speaking to in CLE courses in Georgia lawyers, I say if a case can be removed to federal court, it will be removed. Therefore, you should draw your complaint to meet federal standards because the 12B6 will be filed. Mm-hmm. But I do believe it is not the role of the judge to advocate for a party or not, but there are circumstances where to get a meaningful decision made, the judge does have matters that need to be addressed, but I think the way to address it is to cause the parties to have to address it.
And there are circumstances where you're obliged to address issues sua sponte, right? I mean, some things you have to, right? So.
This is probably a rabbit hole not worth going down, but my least favorite Justice Ginsburg majority opinion of all time is Sinenning Smith, where the Supreme Court chastised the Ninth Circuit for failing to abide by the so-called party presentation principle, the notion that courts are generally limited to arguments made by the parties. I have no problem with the party presentation principle. The irony of that case was that no party had raised the party presentation principle in the Supreme Court. And so the Supreme Court was doing exactly what it chastised the Ninth Circuit for doing, in chastising the Ninth Circuit for doing it. Anyway, yes, ma'am.
Great panels. It seems to me that there's two things that we're seeing that are really intricately involved with this issue we've been talking about. One is the effective, in my view, eradication of Article 3 standing by our Supreme Court. We saw it with SB 8, which I thought was just shocking, and it's gone on with more and more cases involving pseudo-parties who clearly don't have standing. So I can't read everyone's names from here, so I apologize. But the gentleman in the middle who's not a poli-sci guy, but
No.
I think the idea of having some kind of panel, which of course we don't have now under our state of laws, as they do in Europe, to at least review our Supreme Court's decisions on standing would make great sense, because there is no way, as a procedural manner, of dealing with that. And the other thing that I think that's really interesting, this goes to something gentleman second from the front said here, Blakely Glazer, which deals with, are the injunctions expanding or contracting rights? So of course, things like Miranda expands rights. I think there's one of the things, if we had a functioning Congress, perhaps we could enact at a federal level, is to say, if this decision is going to expand rights without diminishing anyone else's rights, then it could be a nationwide or worldwide injunction. But where it will constrict rights, as with Dobbs, as compared to the ones that expand rights like gay marriage, rights to consensual sodomy, Miranda, they're not hurting anybody's rights. There's no reason not to expand. But where you're going to have an injunction that will constrict rights where people had no due process, had no standing because they did not appear in the litigation, that should be federally prohibited. That could be something, as I say, if we had a functioning Congress, we could do to address this situation.
It's a tricky line to draw.
Yeah, I feel like it is. I mean, look, I'm sympathetic to it on some level, but, you know, where you stand depends on where you sit, and sort of like the state of Texas would say, we have rights that are being threatened by the federal government's decision, let's say, not to enforce certain provisions in the, not to remove certain people from the country. They would say it's threatening our rights. And I think it's a hard line to draw. I will say that I think, you know, we haven't talked about, I mean, Kate raised the question, are there ways to distinguish? And the easy answer is, of course, if it's necessary to provide complete relief, then a nationwide injunction makes sense. If it's necessary to provide complete relief to the plaintiff, right? That's easy. I think if not doing a nationwide injunction would create incoherence, like fundamental incoherence, I think that's a little harder, but still makes sense. I think one thing we should appreciate is that sometimes the federal government probably needs a nationwide injunction in some cases. That is, it would be really difficult for the federal government to decide on its own, we're not going to do this anymore, in the absence of an order saying you can't do that anymore, because then they'll get challenged in other jurisdictions saying, hey, why aren't you doing this? And they'll say, well, we chose not to. Well, you can't just choose not to. If you've got a court order, that's one thing, but you can't. So I think we need to acknowledge that there will be times when that's necessary, even in areas where, like, as a substantive matter, the outcome is not consistent with my priors. But
No.
Just on this last question, I think one of the puzzles, though, is that it's not clear that nationwide injunctions are always efficacious.
Right.
So just because a court says stop doing this doesn't mean that the government actually stops. And there are lots of examples, including, I think my favorite is just the Trump v. Hawaii case, where at various different points the court said, you know, you can't do this, but by slow-walking visa applications and giving instructions to personnel, the government got around the court's order. So there's an old-fashioned legal realist question here that we have to wrestle with. I don't disagree that we might need nationwide injunctions. to me it points us towards the other kind of distinctions we might want to make. And I totally agree with Alex. I think the rights expanding or contracting is going to be tough, and I just need to plug a rising legal scholar named Kate Redburn, who teaches right now at Columbia Law School. They're on the market right now, hint, hint. But Kate's work, I think, shows pretty conclusively how you can use the rights language that had been developed to try to expand rights, in particular for LGBTQ folks, and the conservative homophobic movement has picked that up to make rights-based argument on the basis of religion, relying on the very same precedents to try to attack LGBTQ rights. So I'm not sure rights expanding or contracting is the right line. I do think, and this makes me very law professor-y, that thinking about the distinction between, say, vacator and other forms of relief can be useful, and this actually answers your standing question. There's nothing wrong in the administrative law context with precluding federal courts from judicial review. There are lots of laws who do it. There's another great scholar at Penn who's got a paper about this. So if there's no constitutional problem with preventing courts from reviewing at all, there's also no problem with allowing other bodies to make those decisions. So while we don't have something like the Conseil d'Etat, you can totally imagine a world where, in fact, under administrative law, you can't go to a federal court for nationwide relief, but you can go to an internal administrative body inside the executive branch if you want to challenge the procedural adequacy of an administrative regulation or adjudication. That's not how our law is currently structured, but there are no constitutional problems with doing that. And that would help resolve some of the standing concerns you've raised, but only in the administrative law context. It wouldn't speak to things like the Dobbs case, which, as Kate highlighted, don't actually rely on the same legal procedures to achieve nationwide injunctions.
But it goes back to the broader theme, and this is perhaps a good place to end. It goes back to the broader theme that, like, we're going to disagree about exactly where the most important focal points are. We're going to disagree about maybe what the right reforms are. It's long past time, right, for this kind of conversation to move out of law schools and into, congressional committee rooms. And I continue to be sort of flummoxed by Congress's stunning disinterest in exercising power that it actually regularly exercised for 150 years in political climates that were actually not as dissimilar from the current one as we might think at first blush. So,
this is wonderful. Thank you, panel, everybody.